decided that the following people, my Lord, be charged, which is number 1, Longwe Twala, number 2, khumalo, number 3, Gladness Khumalo, number 4, Zandi Khumalo, number 5, Tumelo Madlala, number 6, Mthokozisi Twala, number 7, accused 7, it's Maggie Peer, my Lord. The person who has put us in this trouble, the person who has put this court, this trial into shame is the state, who failed to disclose such a crucial information and decided to charge the accused who are before this court after they have charged other people. And I'm seeking clarity on that, and I'm being told that there is no need to seek for a longer postponement because I can be able to continue with this witness. The gross irregularity that has been made by the state in this case, we have been made to plead before this court when we were not in possession of such crucial information, wherein there are other people who have been charged in this case, and we have already pleaded, my Lord. Then we need to go back and reconstruct all that information. And then the state is not even ashamed to stand up and say we do not deserve a longer postponement. My Lord, I don't know. I need protection, my Lord.
Guys, I would like to ask you this question. If you had a son or your daughter who was born in 2014, what age could be this person? Obviously, that would be 8 years. During these 8 years, what could be this child be to you as a support? I believe this child, you could send them to go and fetch water. They can go to school. You can tell them something. They will give you the help, isn't it? Right now, we are talking about the Senzo Meyiwa case, which took 8 good years in order for it to reach inside the court. During these 8 good years, there are millions and millions of South Africans who've been waiting to see justice in this Senzo Meyiwa case. There are family who still can't sleep day and night because they want to get to know who had killed their son. Yes, in this same murder case of Robert Senzo Meyiwa, it had caused his father's death. This poor man died without seeing the face of the person who had killed his son. This man died because of the stress that he had day and night for seeing one of his sons leaving him in such a way without even saying goodbye. Now guys, tell me, do you know how painful it is for this family to be sitting in front of the TV screen and see what is happening inside the court? After 8 years, they've been waiting for this court to start. Now it is about the matters being postponed every time the court adjourned. Advocate Zandile Mushlolo, she asked for more time in order for her to respond to the new docket that she just received this morning inside the court by the state witness.
You'll notice that it's the second docket because it's in reference of Force Laura's case number 375-01-2019. which is a second docket, in other words, my Lord, in this case.
375.
Force Laura's 375/01/2019. And this statement, my Lord, that is before this court now, makes references of which I would like to cross-examine the witness regarding that. And my Lord, I cannot be able to proceed with cross-examination on this document without reading the whole docket, wherein this statement is contained. After engaging, my Lord, with the state regarding this docket, I have been given this docket, my lord, this morning by the state. As a result of that, I have to, or I need, my lord, with your respect, I need time to go and read this docket so that I can be able to cross-examine Mr. Musia further. Further to that, my lord, in respect of Exhibit C, which is also before this court.
Yes.
I have requested, my lord, the State Council to confirm to me the content, my lord, of this exhibit before I can be able to cross-examine Mr. Musia regarding the content of this document, and also in order to determine if there is any need to cross-examine Mr. Musia regarding this document. I've also requested the state, my lord, because this exhibit is relevant in preparation of accused number 5 defense case. In that, my lord, Exhibit D refers to the facts, same facts of this case, my lord, that it is before this court. But it was opened later in 2019. And in Exhibit D, my lord, the Director of Public Prosecution, South Gauteng, had decided that the following people, my lord, be charged, which is number 1, Longwe Twala, number 2, khumalo, number 3, Gladness Khumalo, number 4, Zandi Khumalo, number 5, Tumelo Madlala, number 6, Mthokozisi Twala, number 7, accused 7, it's Maggie Peer, my lord. On 2 counts, my lord. Count number 1, the DPP has decided that they must be charged on the count of murder, in that upon or about the 26th day of October 2014 in Etonie, Boksburg, in the sub-district of Eguruleni, the accused, whose name I've just read into the record, my lord, who acted as perpetrators or accomplice or accessory after the fact, unlawfully and intentionally killed Senzo Meyiwa, an elder person, by shooting him. And count number 2, my lord, is defeating the ends of justice. In that, on or about the date and at or near the place mentioned in count 1, the accused did unlawfully and with intent defeat or obstruct the cause of justice, commit an act to wit, accused number 1 to 6, they hatched a plan and informed the police that they were robbed at gunpoint by unknown persons. Accused 7, she claimed the crime scene prior to the arrival of the police, which acts defeated or obstructed the administration of justice. My lord, as a result of the content contained in this document, it shows that there is a conflict of interest, but I cannot be able to make that submission before this court until I get a confirmation, my lord, from the author of this document before I continue with the cross-examination and any submissions further, my lord.
Can you repeat the names of the people who are supposed to have been charged?
Charged. Thank you, as the court pleases, my lord. The name of those people, my lord, as per the exhibit C, my lord, which was not brought by myself. The person who was supposed to be charged is accused number 1, Longwe Twala. Accused number 2, khumalo. Accused number 3, khumalo. Accused number 4, khumalo. Accused number 5, Tumelo Madlala. Accused number 6, Mthokozisi Twala. Accused number 7, Meyiwa. My lord, as a result of that, my lord, if there are 2 decisions taken by, one taken by the Director of Public Prosecution South Gauteng, and the other one taken by the Director of Public Prosecution North Gauteng to charge the accused before this court, then I need clarity on that, my lord, from both or from the NPA before I can be able to proceed with cross-examination regarding this document that is before this court, my lord.
Advocate Zandile Mushlolo, she slept and woke up this morning inside the Pretoria High Court just to find out that she's in front of the 2 dockets which are being presented to her. One, which allowed the arrest of the 5 accused which are behind bars. 2, which also allowed that people who were in that house that night where Senzo Meyiwa was killed, they should have been arrested and be behind court bars as we're speaking. Unfortunately, that have not happened. Instead, we only have 5 accused who are behind bars and other 7 people which the public prosecutor had signed the document so that they can be arrested. These people, they're still free out there. That is how this matter of Senzo Meyiwa is being very complicated right now. Honestly speaking, on my side, I really don't understand what is going on with the state advocate Baloyi. I'll tell you why. Guys, you had received this docket so long time ago. Why did you not go and try to give it to the defending attorneys so that they'll have it in the possession and try to work on it? Come to think of it, in this second docket, it mentioned how the public prosecutor had signed for the arrest of these other people who were in that house where Senzo Meyiwa was killed. And they signed 2 dockets. The first one which confirmed for these 5 accused who are behind bars to be arrested, and the second one which mentioned the names of Longwe Twala, khumalo, a mother, a sister, and Senzo's 2 friends who were there in that house, so that they should be arrested. Why did it not apply this second docket? Why do they have to go and arrest only these 5 accused who are behind bars that we are seeing inside the court, while there's still some other people who are supposed to be inside the court? Now you understand when they say there's no smoke without fire. And this smoke has been winding on one side of the story, which everyone keep on assuming that the right people who are supposed to be inside the court is the people who were in that house. Them that the one who have to come to the court and get to tell us exactly what had happened to Senzo Meyiwa on that night. Advocate Malsela Tefo came forward and told the court that the 5 accused who are behind bars, they're not the right people. And the people who should have been inside the court is people who were in that house. Instead, some people saw Advocate Malsela Tefo like someone who's not polite, someone who's trying to disrespect the court, someone who's very arrogant. That's not the case. The guy have raised the point because he knew. And he have the evidence. You guys, you saw how he described to the court, telling the court that there are witnesses who will come forward and tell exactly what had happened. And that is how even the name of khumalo had come to the court, because they said khumalo had accidentally shot Senzo Meyiwa with the gun which came from Longwe Twala.
My lord, in response, my lord, it is surprising to hear the state telling me that I need to be given a short adjournment when the state has put on record that it came to the attention of the state on the 23rd of March, my lord, before we started this case, about the existence of this docket. And yet the state failed to disclose such information to me, my lord, before starting this case. I understand that the condition of the witness is not good, my lord. However, here, the violation of the constitutional right of the accused, number 5, is imperative, my lord. And my lord, with due respect, I cannot be told by any of the counsels before this court as to how long do I need to do a preparation regarding the documents that I've just received now. And also myself, it will be unfair for me to tell them as to how long do they need to read that document. It's a further prejudice, my lord. It's a further disregard of accused number 5 constitutional right by the state. And a misjoinder of the accused in this case. We are sitting with a critical situation here, my lord, wherein I'm seeking clarity from both DPPs regarding Exhibit D, wherein they decided to charge other people and later stage decided to charge these people. I cannot be able to proceed without receiving a confirmation by way of a letter, my lord. I don't need witnesses here in this court. I need a letter, my lord, from the DPP confirming the status quo of the document that is before this court. Then I'll be able to move forward. And also in respect of the line of cross-examination that I need to do, my lord, to this witness, I cannot be told by the state, I cannot be told by anyone, my lord, with due respect, whether I should cross-examine or whether I should not cross-examine. That's accused number 5 constitutional right to decide how to conduct his case, my lord. The person who has put us in this trouble, the person who has put this court, this trial into shame is the state, who failed to disclose such a crucial information and decided to charge the accused who are before this court after they have charged other people. And I'm seeking clarity on that, and I'm being told that there is no need to seek for a longer postponement because I can be able to continue with this witness. You know, that is very unfair, and it's very wrong coming from the state. The NPA, my lord, is not supposed, and he has got no right to charge people the way they want. As much as they are given, they've got rights in terms of the constitution to decide, to make decision on the people to charge. But also there is a way, there's an administrative way of conducting such decision. In terms of section 33, my lord, of the constitution, just administrative reasons. Accused number 5 has to be informed of the reasons about the decision taken in Exhibit D because he is affected. He's an affected person, my lord. And until we receive those reasons, we will then be able to inform this court whether we're able to proceed or not. Just administrative reasons. Section 33 of the Constitution. The state must give us reasons, must provide reasons for the decision that has been taken. Whether there has been a misjoinder, or maybe we're supposed to be having 10 accused here. The other accused should have been joined here, or they should not have been joined. We don't know, my lord. As a result of that, my lord, I am asking that this matter be adjourned, and the remaining period of this session, which is until next week Friday, will be insufficient, my lord, for me to prepare this case. And And therefore, I need a postponement further than to next week Friday, my Lord, so that I'll be able to read, consult, and then prepare further for this case. My Lord, once more before I sit down, the gross irregularity that has been made by the state in this case, we have been made to plead before this court when we were not in possession of such crucial information, wherein there are other people who have been charged in this case, and we have already pleaded, my Lord. Then we need to go back and reconstruct all that information. And then the state is not even ashamed to stand up and say we do not deserve a longer postponement. My Lord, I don't know. I need protection, my Lord, from this honorable court, my Lord, that I am asking a reasonable time. A reasonable time, my Lord, will not be the remaining period, which is from today until next week. Then, depending on the availability and depending on the role coordinator who is coordinating the role, my Lord, we can then be guided of a further available dates for this court to resume again, my Lord. Those are my submissions.
Now that the two docket is here, it's about time for them to start arguing between the defending advocate and the state advocate, Baloyi, who's now trying to impose the time limit for advocate Zandile Mshulolo. She should try to make it short so that his witness, Thabo Mosia, will be able to come to the court. Otherwise, he won't make it because of his health conditions. Like, really? You had just bring this document to this person today morning. They had received it today and they are under examinations. They should have go forward and finish. Now that you are bringing this, which means you need to give them enough time for them to go ahead and read and try to understand what is this all about. Because it is in this same docket that Advocate Malisela Tefo had bring up to the court and explaining that Kelly Khumalo, she's the one who had pulled up the trigger to kill Senzo Meyiwa with the gun which was brought inside the house by Longwe Twala. It is in this same docket where Advocate Zandile Mshulolo, she had just explained to the court the names of the people which the public prosecutor had signed so that these 7 people who were in that house, they should have been arrested and appear before the court. The court have been postponed for next week Monday. So it will be next week Monday whereby we'll get to know whether this court is going to be postponed for the near future or it's going to be postponed for so long. Right now, everything's relay now in the hands of Advocate Mshulolo. She's the one who will have now to tell us whether she's ready to go ahead and finish examinations or not. She's the one who will have to decide whether they should postpone for the near future or whether they should wait until October, because that's what we saw from the state advocate who said that if they have to postpone it, which means they will have to postpone it for another couple of months, which will be until October. And as we all know, October is not today, guys. It is about in 2 or 3 months to come. Yet the family of Senzo Meyiwa, they still have to wait again in order for them to get to know exactly what had happened. What I like about today's court is that the fact of judge trying to plead in behalf of Senzo Meyiwa's family, the public or people of South Africa, or should I say globe, who are waiting to see the justice being done in this murder case. And he asked 4 of them, I mean like the 4 parts, that they should try to come up with a proper solution because he don't want this matter to relay forever. Have listened first to what he said.
I see that in your answer, you, on behalf of your client, preparing yourself for acquiring readiness for purposes of the way forward. But there's a suggestion I made to say that we need to come together. All of us engage those who are responsible for drawing court rolls.
Yes, ma'am.
Who will be the role planner, and then the JP or the DJP in this division, in terms of aspiring to enroll this matter en bloc.
Yes, ma'am.
I'm raising this because in other matters that with similar or even different length, I have seen that matters can be enrolled and blocked so that you deal with the matter. And I'm saying the justification, the specific justification in this matter is that it took forever from the day of the incident to the day it saw its day in court. So you did not address that.
Oh, my apologies, my lord. Thank you for
and whilst you are about to address, it has been suggested that the remainder of the days in this week can be looked at in terms of putting together a meeting that can achieve that objective.
Yes.
So, all I can say is that as for me, whatever I do or do not do, I keep in mind that there are people in custody. I keep in mind that there's a family that has buried a son, and there's a country, if not the globe, that has lost a remarkable individual, and that matter has been brought into our hands. It is up to the four of us to say to it that justice is done in any manner whatsoever, be it in the trial, be it in the postponements and whatever. So in line with the agreement now, this matter is postponed up until next Monday, so that we can be able to determine the way forward. I must just indicate that as the presiding officer, I did attempt to interrupt. I do not agree that with the situation as it is, Advocate Mishololo should be told when to be ready. I'm not saying anybody did, but I think we are saying she should be allowed reasonable time, and she has told us that that reasonable time shall be determined by the dynamics that shall confront her as she prepares from now. She also raised a matter that I didn't hear addressed.
Now tell me something, who's benefiting from this crime? Who's benefiting from all this nonsense that we are seeing so far inside the court? Let us have pity, guys, and try to make these things go faster so that the family, they can get to see what had really happened to Senzo Meyiwa. I hope you have enjoyed watching this video. You have get the latest updates or news about Senzo Meyiwa murder case. If you don't want to miss any of our video in the next future, please do subscribe to the channel. Give us your thumbs up. We will really do appreciate that. Most of all, turn on that your notification button right there so that you don't get to miss any of our videos. I'll see you again very soon. But for now, continue to be yourself. Be good, be kind. Have respect for everyone in order for you to be respected. May God bless you all. I'll see you again very soon. Ciao, ciao.